right. Well,
that's the division's expectation with their case and what they want to see happen. What they want to see happen. So that's the PCIT issue. I think the court wanted me to weigh in on Mr. Mortensen's assessment. I don't know who the assessors talked to or didn't talk to. Obviously, in Ms. Paul's assessment, the assessor laid out very specifically what she did and who she talked to. That section doesn't seem to be present in Mr. Mortensen's evaluation, but that doesn't mean that he didn't talk to folks. My understanding in talking to Mr. Tapusoa is that he doesn't have any issues with Mr. Mortensen's assessment, and he would like to see him follow through with the recommendations. I would note that in Mr. Mortensen's assessment, one of the recommendations is to, as you've noted, engage in trauma-specific psychotherapeutic treatment, and specifically it mentioned EMDR, which is what I think is going to happen. I would note that in Ms. Paul's assessment, it actually specifically says evidence-based therapy to treat PTSD symptoms. This is actually a higher level of care than domestic violence treatment and should be considered as part of the recommendations. So I'm frankly satisfied with both assessments and both recommendations, and I just hope the parents will follow through. I think finally, the court made a comment at the last hearing that I forgot to touch on, but the comment was that the parties really need to kind of focus on themselves and fixing their own problems rather than focus on each other and what each other are doing or not doing. And I think that would be a helpful way for these folks to move forward in this case. In speaking with Mr. Tapusoa in the division, I think that they feel the same way. I think that's what needs to happen.
Okay. All right. Let me go ahead and make some recommendations. Well, I think that when we first came into court today, when I heard from the guardian ad litem at first, that was pretty much in line with the same kind of thinking that I had walking into the hearing here today. I was prepared to be lifting supervision today based on my reading of the assessments as well. There may be some things that could have been brought up, some issues that could have been raised perhaps by Mr. Mortensen in the course of his assessment, but I'm not sure that he had to, that would have been an expectation of him going in. I think these assessments, while they are largely based on self-reporting, are also driven by the therapist as we go through this. And I think there's a lot of information in the assessment that shows that he was focused on certainly some of his own issues. And it was mentioned the substance abuse issues in the past, which were, quite frankly, would have been a real concern if this were 3 years ago, perhaps. But we're here today, and there really haven't been allegations that currently he's suffering from those kinds of substance abuse issues that he did in the past. It may be a lifelong process there as well. I did also mention at the prior hearing that I was inclined to take baby steps, and the question arose when Mr. Swinyard, when your declaration, the updated memorandum as to why she was supervised and not him, and I have to say I've given that a lot of thought, and because if this were a case where, say, it was only a finding against Mr. Mortensen for domestic violence, it's conceivable that he may have been supervised as an outcome too. I think as I thought about it more, part of the reasoning was that we had a situation where there was already a criminal case where there were that Ms. Paul had gone through, and she'd already been ordered through treatment, and then there was this subsequent incident that also had taken place. And so there was a real concern about whether anything had been learned from that first experience. I mean, that was a felony charge that she had gone through, and yet there was this other incident. And that may be what was driving that. And it certainly, before we had the hearing where I made the recommendation for mutual orders, that's the information. That's really the only information I had at that point. When we were talking about the ex parte order, and then we were coming back, we had set it over, had additional time, came back before we had the actual hearing on the merits. So lifting supervision is certainly part of the order. I also, though, want to make a recommendation in addition. And I think this should also get into this order should also be put into the domestic matter as well, that the parties should be following the recommendations of the DCFS. And if that includes PCIT or EMDR, then that should be part of it. I think that that's important. So if there are any releases that are needed to make that happen, I want the parties to execute those releases. Otherwise, I may be back here making a Rule 70 order authorizing the clerk of the court, or authorizing one party authorizing the clerk of the court to sign on behalf of a parent if that's what the therapist requires, or just simply allowing each parent to engage in that on their own without the consent of the other party. But I want them to execute those releases. And then let's see here, those consent forms as they may be. So stay in treatment. That's another part of the recommendations, to stay in the individual therapy. They should all have a domestic violence component to the therapeutic process. And I didn't really get the impression that looking at the assessment either that Mr. Mortensen was taking the position, as was represented, that he walks on water and she's the devil incarnate. That's just not the impression that I'm getting. I certainly do think that both of them have a sense that they are the victims and not the perpetrators. And I get that. I think that that's not unexpected. I think what my main concern is over time, as we've talked about in the past, is having the dust settled from the fallout that that came when these matters were both filed. And it may be that no matter what we do, we won't be able to change their opinions that they have of each other. But the main concern of the court is to prevent further acts of domestic violence. And if we can have the hope that someday we can have a child that can see the parents in the same place getting along with each other, that would be great. But now it's not that time. It definitely has been my concern, and it has been my belief that I could keep them away from each other, at least now, until there could be some measure or demonstration of increased maturity along those lines, where they can be in the same place at the same time without it turning ugly fairly quickly. That would be certainly a long-term hope, but I think we're also a long ways away from that. And as was mentioned too, there is in the stipulation that was entered into, there's now a motion to set that aside. But regardless, I would want the provision regarding a restraint on making disparaging remarks against each other to also have that be a part of this order today. So it's become something that it's enforceable. So now we're getting into the area of what should we do about parent time. And I did indicate, as I just said, too, that at a previous hearing, I was inclined to take some baby steps for those reasons that I also indicated about why she had ended up supervised, but not him. So really, where I'm not inclined to go all the way back to the terms of the stipulation, but really, what I'm weighing is whether I should go a little bit more than what the statutory minimum provides. I do have some concerns about maybe why parent time was awarded but not exercised. But there also was some explanation about that in terms of availability of the supervisor. If we don't have supervised parent time, then we don't have that issue arising as to whether or not parent time needs to be cut short. For example, if there's no supervisor available. There is certainly a dispute about who's been the primary caretaker of this child from infancy until now. And I didn't think there was really much of a dispute that there was at least a period where Ms. Paul was away because she was involved in filming of the reality TV series that she was involved in. Although it was my impression too that at some point both of them may have been involved in the reality TV aspect as well. I think that what I'm going to do, I think we need to get a private guardian ad litem in on the domestic case. I'm inclined to set it for a review in the domestic matter. And I want to give the parties, today's Tuesday, why don't we say till Friday, the end of work day on Friday, to see if they can't stipulate as to who a private guardian ad litem should be. I don't get the sense that we're talking about a pro bono private guardian ad litem. But I also don't have financial declarations in the domestic case to make a determination about how those costs should be allocated. So I'd like those in the domestic file as well by the end of day Friday. So then when we come back next week, I can take a look at it next week. Well, I'll just come in and do a paper review on that and make a determination. Hopefully you can come to some agreement on who that private guardian should be. If not, then why don't we have a new statute now that talks about those kinds of how we go about the selection process when it comes to custody evaluators and therapeutic intervention. Why don't we just apply that to the selection of a private guardian ad litem as well? If you can't come to an agreement, look at that new statute in terms of how selection is made. It's basically the same kind of thing we've been doing all along. Some of it's implicit that's now been made explicit by statute. Submit 3 names. If you have any objections to any particular person, state the reasons why, if there's conflicts, for example. And then the court can make that selection. I'm hoping we're getting to a point where they can start making some agreements between themselves. I know they went to mediation and didn't come to an agreement, although I'm grateful that at least they're trying in that respect. So from now until the next hearing, and we'll get you a date now before we leave, I'm going to recommend that supervision be lifted. I'll recommend parent time pursuant to Utah Code 81-9-302. And that would mean that Ms. Paul can select the midweek day on that, and then she can have the entire alternating weekends and one midweek day that's not overnight each week. And but we want that day to be consistent, so that we are on a set schedule, that everybody knows what they have the same expectations as to where the child is supposed to be, same time, same place. I'm trying to recall what we did about exchanges, how they were to occur. Were we using third parties to do the exchanges for them?
Third parties, that's correct.
Okay.
We do have, the guardian has recommended, Mr. McDonald has recommended a coordinator. I don't know if that would work for the exchange, but I think we could use that coordinator in the event of any concerns.
The coordinator wouldn't work for the exchange because she's not in the state of Utah.
What was the coordinator's role then?
So the coordinator, who never really got into playing her role, was basically going to coordinate the parent time each week. And then what was happening? Yeah, correct. And then what was happening is the supervisor was sort of facilitating the exchange, if I remember, in a Harmon's parking lot.
Well, the statute really does permit a parent to designate an individual who's known to the other party and who the child is familiar with, as long as the parent will be back. That's just for exchange purposes. I want the parent to be available. I don't want the parents to be sending somebody to do parent time exchanges on behalf of a parent when that parent's not going to be there as soon as the exchange is complete. All right. They still have to stay 100 feet away from each other, but the intent is that if third parties are doing the exchanges on their behalf, that once that person who's retrieving the child gets back to the residence where the parent is, that the parent will be there, so they'll be exercising their time. All right. Am I missing anything here or is there any need for clarification?
Your Honor, by which date would you like my client to elect her extended parent time for the summer?
Well,